Maintenance, as in any other area of law, has rules that applies to it. Now, sometimes these rules are set in stone, and there's nothing anybody can do about it. Sometimes these rules are more like guidelines, because at the end of the day, the courts have the discretion to make decisions in this regard. Let's get started on the first one there. Best interest of the child versus affordability. So sometimes an approach that parents follow when it comes to calculating maintenance is they take a look at their net salary at the end of the month after they've paid everything. How much money do I have available? And we'll start the maintenance calculation based on that. That's actually not the right approach. We need to base the maintenance calculation on the needs of the child. At the same time, it needs to be practical and it needs to work in the real world. So I'll give you an example. A child has a particular aptitude, let's say for instance for piano, and with the right kind of guidance and very expensive tuition, this child is going to be the next Mozart or Chopin. Now, does this necessarily mean that the parents have to pay for this expensive private tutor? No, they don't need to. Not unless they really do have the money for it. Okay, so the living standards of the parents does determine whether a particular expense is going to be considered or not. Moving on to our second one there, quite often when parents have disputes over maintenance, it's because one of the parents, has a bit of a grudge against the other parent, and this is why they're not paying. Now, what they're forgetting is that maintenance is actually for the child. It's not for the other parent. The other parent is receiving this money and they're acting as the custodian. But it's not really their right. They are basically, they're custodians. It's the child's right. Okay, on to our third one. Fathers are presumed to be able to pay maintenance until they can prove otherwise. So I think that one's pretty straightforward. When it comes to unmarried fathers, these fathers do not lose their obligation to pay maintenance. Simply because they were never married doesn't mean that they can skip out on maintenance. Same goes for parents who go through a divorce. So if the parents do get a divorce, then maintenance does need to be paid. Married or not, unmarried or not, divorced or not, doesn't make any difference. The child has a right to be maintained. Okay, let's move on to the other side of the screen. So there used to be a concept of feathering the nest in South African law, which said that, let's say for instance, I have a child with my ex-wife, and now I'm having a new child with my second wife. What used to be the case was that I wouldn't be able to reduce maintenance payments to my first child because I have an additional child now. That's actually not the case, because the courts consider maintenance to be a unique right for the child. So in practice, if one does have more than one child, then ultimately the amount of money available to support these children does get reduced. Okay, an interesting case of stepchildren. Okay, so let's use an example again. Let's say, for instance, that I have a child by my ex-wife, and I'm not able to pay maintenance. Is my current wife responsible for maintenance payments? In short, no. There is absolutely no obligation on my current wife to pay maintenance or to be financially responsible in any way for her stepchild. However, there is a caveat here. If we are married in community of property, me and my current wife, what it means is that my ex-wife would be able to claim money from the joint estate because we're married in community of property. So in this way, my current wife is not going to be responsible for current maintenance. However, if there is an arrears maintenance claim, then that money may be taken from the joint estate, and indirectly she will become responsible for her stepchild. When it comes to adopted children, as you can imagine, these children have full rights. Guardianship has been moved to the adoptive parents, so they can claim maintenance from the adopted parents. And if the adopted parents do get divorced, then they can claim maintenance from each other to support the adopted child. Lying-in expenses refers to those expenses when a woman is pregnant. So there's a lot of costs involved here. prenatal vitamins and sonars and all kind of health checks, and even a room that needs to be made up for the baby that's on the way. All of these things are already expenses that the child is incurring even before the child is born. So when we calculate maintenance, we are going to include those expenses in the maintenance calculation. Let's use an example again on myself. Let's say, for instance, I remarried and my previous wife receives a SASSA grant, a government grant for our child. Does it mean that I am exempt from maintenance? Of course not. I still need to make maintenance payments. At the same time, when it comes to the maintenance calculation, we are going to take into consideration the SASSA grant that my ex is receiving. What about tertiary education? Do you think children can claim maintenance for university? Absolutely. So even though the age of majority is now 18, remember that children are entitled to receive maintenance for the duration of their natural lives. So absolutely, children who are at university can claim maintenance from their parents. Now, this is a bit of a tricky one. It's actually one of the items that was discussed at the SA Law Reform Commission in 2016. And this is where children over 18 need maintenance. Now, the way that the law is set up at the moment is those kids actually have to approach the court on their own, and they need to sue their parents for maintenance. So, I mean, purely from a family point of view, this is catastrophic. So they are working on that, but at the moment, the legislation as it is says that children over 18 do need to approach the court directly on their own, and they need to sue their parents. So even in situations where a child may be employed, let's say, for instance, they finished their degrees, they are now 21, 22, 23 years old, and they are working, but they're working as interns, and they're working for very little money. Are they able to claim maintenance from their parents? Absolutely yes. Okay, so this is just our first slide. Let's take a look at the second slide of principles.